Hi. Following last week's discussion on jurisdiction and immunities, so basically how international law creates and maintains separate spheres that are under the sovereign control of states, and some exceptions to that, I now want to turn our attention to the question how international law in turn is incorporated, or indeed not incorporated, into domestic or national legal orders. In this first clip, I'll introduce the two main approaches that exist here, the monist and the dualist approach, before then in the second video turning to the question of the judicial enforceability of international law, which of course is the determining factor or the determining question when it comes to the role that domestic courts play in international law. Before we get into the weeds, I would like to point out the immense relevance, but underestimated relevance, of domestic courts for international law. We habitually hear about the activities of international courts such as the European Court of Human Rights or indeed these days the International Court of Justice, but the truth of the matter is that domestic courts are actually often at the front line of the enforcement of international legal obligations. In fact, in some cases, in some legal domains, we even have a requirement of going to domestic courts first. In international human rights law, for example, you as an applicant firstly have to exhaust all the domestic local remedies. So you have to go through all the stages in the national legal order before you can then address your claim, your grievance to an international human rights court. Or if we look at international criminal law, we see in the Rome Statute of the International Criminal Court that the ICC only plays a subsidiary role, meaning that it is the task of the national authorities, domestic prosecutors, to indict, prosecute potential war criminals, persons that have engaged in crimes against humanity, and so forth. And only if this doesn't happen, if in fact these domestic authorities are unwilling or unable to perform this task, only then can we address a crime at the international level. So this question of the relationship between international law and domestic law, and specifically the incorporation of international law in domestic law, might sound theoretical at first when you read through this textbook chapter, but in fact it is inherently practical, and it is one of the most important questions if we want to understand how international law becomes effective on a daily basis. Looking at the number of states in the world and the differences that exist in terms of their political and legal systems, it will probably not come as a surprise to you that the answer to the question of how international law is incorporated in domestic legal orders very much depends on the constitutional outlook of any given state. It is for this reason that as international lawyers, we basically distinguish between two ideal types, monism and dualism, which, if we imagine them to be the opposite ends of a spectrum, covers most of the practices that we have in the international community, with states largely falling somewhere in between but tilting to the one or the other side of the spectrum. The first approach is the monist approach, or in short, monism. And being in the Netherlands, we in fact live in the country that is usually taken as the prime example of a monist constitutional system. In a monist system, the domestic and the international legal order are one and the same thing. They're integrated, which means that the moment that a state has signed and ratified a treaty, it becomes also the law of the land. And as such, domestic judges are not just able to, but in fact obliged to apply these treaties in this form directly to the cases that they are confronted with. Another implication of this situation is that the pronouncement and decisions of international courts and tribunals, think for example again of the European Court of Human Rights, are of direct relevance also in the domestic legal order, in the sense that these interpretations concern the very same instrument, the very same legal source that domestic judges are applying as well. Whereas, as we'll see in a second, in a dualist system, the corresponding incorporating act is in fact a separate legal source from the international law that gives rise to it. This leads to a highly dynamic situation, not just in terms of interpretation, which is then shared, so to say, by domestic and international judicial authorities, but also in terms of legal practice, in the sense that an individual who wants to invoke their human rights, or a company that wants to rely on an investment treaty, can directly use these international legal sources to make their claim at the domestic court. So if, as one of these entities, you believe that your rights were infringed, that you have a valid claim, you don't have to go to any corresponding domestic legal act. You can directly bring this international treaty and base your claim on this. By contrast, and as a logical corollary, In a dualist system, the domestic legal order and the international legal order are two separate, distinct systems that from the outset do not have anything to do with one another. In fact, if an international legal obligation is supposed to trickle down to reach the domestic level, it requires a corresponding implementing act that goes through Parliament, and only then, in fact, do we have rights and duties, do we have legal obligations as outlined in the corresponding international instrument. So to stay with our examples of the Netherlands and United Kingdom, in the Netherlands, the European Convention on Human Rights is directly applicable in domestic courts. And in fact, given that it counts as even higher than domestic laws, the rights protected in the Convention have come to play a role that is similar to constitutional protections in other countries. Whereas in the United Kingdom, the European Convention on Human Rights is legally irrelevant until and unless, of course, we actually rely on the 1998 Human Rights Act, which article by article implements the very same rights that in the Netherlands you could apply directly from the European Convention on Human Rights. In other words, to reach their decisions, domestic judges in the UK, for example, have to rely on the incorporating domestic legislation, which, because it is considered to be a wholly separate source from the international law that gave rise to it, can therefore in principle also be interpreted differently and in separation from international courts and tribunals. The advantage of the system is that it provides a shield, a protection for domestic legal orders from unwanted penetration by, for example, treaties or judicial decisions by various international courts. Domestic institutions, in particular the legislature, but also the courts, are in charge of the law of the land, are in charge of the legal obligations that are applicable within the jurisdiction of this dualist state. This being said, if the discrepancy between the international legal obligation and the corresponding domestic act is too large, a state runs the risk of actually breaching that international legal obligation. So therefore, both the legislature and domestic judges usually try to align the two and forego there being a breach just because they have departed too far from what was originally intended at the international level. To sum up, there are various advantages and disadvantages to each system. So if the monist system is more dynamic and perhaps more effective, not just in implementing international law, but also in preventing breaches, the dualist system provides more protection and autonomy for the domestic legal order. And given these various pros and cons, it probably won't come as a surprise that various states have chosen various paths and have somewhere along the spectrum between monism and dualism chosen how to incorporate international law into their domestic legal orders. This concludes this first clip. In the second one, I'll look more specifically at the question of judicial enforcement, also on the basis of a few chosen examples that illustrate how this happens in practice.